Item number 3, Lordship.
Item number
3, on behalf of the petitioner, Mrs.
Three.
R.D.B. Lordship.
3.
Item number 3, Lordship.
Yes.
On behalf of R.D.B. Mrs. R.D.B. Lordship, she has got some medical emergency, Lordship, so she could not.
Medical.
Medical issues, and probably she is at
Okay.
Kolkata, Lordship.
Heard, Mr. What is your name?
A.R. Tohbildar.
A.R.
Tohbildar.
Tawbildar, Learned Counsel, appearing for Miss R. Devi, Learned Counsel for the appellant, who prays for an adjournment on the ground that there is some medical urgency of the learned counsel for the learned engaged counsel for the appellant, and hence an adjournment is prayed for. The prayer is allowed. Let this matter be listed
After 4 weeks, Lordship.
after 4 weeks on a date to be fixed by registry.
May it please your lordship. Lordship matter regarding listing of a pending intestate application, lordship, which was last listed in the month of August, lordship.
In hearing column,
No, admission column, lord.
okay.
In the next week, lordship.
It has yet to be admitted.
Yes, lordship.
It is not yet admitted. Okay.
Similar, my lord.
5th of March.
Similar affair is also.
5th of March.
We have given 6, my lord, 6.
Okay, 6th of March.
May it please the Lordship. My lord, I am praying for an upgradation of a matter, my lord, which, my lord, I have mentioned last night, my lord. My lord will remember this. Item number 50, my lord. If that can be taken at 2 p.m., my lord, there is some urgency.
Item number
50, my lord. That is the LA appeal of IIT, my lord.
what is the
My lord, the urgency in this case is this, my lord. It is the appeal has already been admitted in this case, but the stay application was not there. And we are IIT's, my lord, apprehensive that the other party will now go for the execution in this case, my lord.
execution has
My lord,
yet to be filed?
probably, my lord, the notices have not been received because the party main here is the state of Assam. State of Assam through the director, through
You
the.
have informed the government council.
Lord, I will now inform the government council.
We'll take it up at 2.
Deep level, my lord.
Provided you inform the
My
government.
lord, I'll find it out the government council, please.
Okay.
Deep level.
May I please your lordship, with the consent of the other side, I beg to mention item number 22 and 47 of daily list, lordship.
What is the prayer?
Prayer is for seeking adjournment, lordship. Engaged counsel father expired on 23rd of February, so he has to rush.
You are for?
I am for A. Bhattacharya for the appellant in both the cases.
Heard, Mr. What is your name?
N. Burman
Heard, Mr. N. Burman,
on behalf of A. Bhattacharya
learned counsel appearing on behalf of Mr. A. Bhattacharya,
for the appellant.
learned counsel for the appellant, who seeks an adjournment on the ground that there is a bereavement in the family of the engaged counsel for the appellant. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the prayer. Hence, the prayer is allowed.
Lordship, one prayer submission is there. If both the matters are fixed on 24th of March.
Let this matter be listed on 24th of March. Paribu? 24th of March.
If you please.
May I please? Item 23. We were almost ready for the hearing, but then some more new evidence surfaced and we have realized that there are many disposed cases within the High Court. Now we started looking for those and we have not been able to get the certified copy very quickly. Because they are disposed cases, they are having to find them first before we start applying for the certified copy. We are going to receive one today. And that is the reason we need some more time. And I'm on leave because of my son's board exams. So any date after 9th of April may be fixed.
You have informed the other side.
We have taken consent from the other
Heard
side.
Miss A. Saikya, learned counsel for the appellant, who submits that the appellant intends to bring on record certain documents in regard to the pending cases as well as disposed of cases between the parties in this High Court, and seeks some time for the same. The learned counsel for the appellant also submits that she has informed the learned counsel for the respondent regarding her prayer for adjournment, who has no objection to the same. Hence, the prayer for adjournment is allowed. 29th May first week of June. 4th of May.
Fourth. Much.
May please your lordship, I beg to mention listing of two MFAs which are in the hearing column in the first week of April.
It will come in orders column first
Okay. no.
in the first week of April.
May I please your lordship? Lordship, I am praying for listing of two MSc appeal for orders in any date your lordship pleases.
Okay, orders,
Orders,
2nd of March.
oblige your lordship.
My lord, this is the matter appeal, my lord. It may be listed on Friday for admission, my lord.
Why Friday?
Parties have come into a settlement, my lord.
Okay, Friday.
Your lordship, I beg to mention an FAO, your lordship, FAO 55 of 25. It had last come up on 3rd September 2025. We were required to take steps. After that, the party for the respondents have filed their wakalatnama subsequently, your lordship. So
So it will come in orders column, 5th of March.
little later after 13th. 14th.
16th of March, yes.
Much obliged.
May please your lordship, I beg to mention item number 21 lordship. Due to medical emergency, my senior is out of station lordship. Kindly matter may pass out for the debate.
Heard Miss P. Sutia, learned counsel for the petitioner / appellant who seeks an adjournment on the ground of medical urgency of the conducting counsel for the petitioner / appellant. The prayer is allowed. Let this matter be listed on 6th of March.
Admission, item 1 and 2.
Mayor, please.
Yes.
But I am for the respondent, my lord. The matter relates to the payment of contractual bill, my lord. There is a possibility of settlement, my lord. So I pray for the final opportunity for the settlement only for 2 weeks, my lord.
Let it be the last opportunity, Your Lordship, because earlier also there was a thing. So if it is settled outside, I have no issue here.
Okay.
But
Okay,
If it
heard
is
Mr.
settled, then we proceed here.
Heard Mr. A. Bishwas, learned counsel for the appellant / petitioner. Also heard Mr. S. M. Barua, learned counsel for the respondents. It is submitted by learned counsel for respondent that there is a possibility of amicable settlement between the parties, and therefore he prays for 2 weeks' time so that matter may be settled amicably between the parties. The prayer is allowed. Let this matter be when
12th, if you're 12th of March, if it is convenient.
12th is okay. Let this matter be listed on 12th of March.
Highly obliged.
Oblige, my lord.
Item 4.
May I please your lordship?
Lordship, basically, Lordship, in this petition, Lordship, the petitioner has challenged the judgment and order passed by the learned member of the Lordship MSCP, Vishwanath Lordship. Lordship will find a page number 11, Lordship, which is start from page number 11. The Honorable Court,
What is your name?
D. Sharma, Lordship. My name has not been reflected in the cross list, Lordship.
Heard Mr. B. Sharma.
D. Sharma,
B. Sharma.
about D.
Sorry. D. Sharma, learned counsel for the appellant. Also heard Miss, what is her name?
S. Khatun.
S.
I
Khatun,
beg for respondent number 3 on behalf of SI Akam.
appearing for respondent number 3. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant impugning the judgment and order dated 12/3/2024 passed by the Motor Accident Claims Tribunal Bishwanath in MAC case number 146/2015 D. Who are you?
Lordship, I am the owner of the vehicle, Lordship.
You are directed to pay.
Yes, your Lordship. Since I have, Lordship, taken the comprehensive insurance policy, Lordship, which covers everything, Lordship.
The appeal is admitted. Let the records of MAC case number 146/215D within bracket D be called for from the concerned tribunal. Let also notice be issued to the respondents. Since Ms. Khatun has appeared for respondent number 3, no formal notice need to be issued to respondent number 3. You have received the memo of appeal. However, the appellant shall furnish the
Maybe sharp.
furnish the memo of appeal along with annexures and annexures to the learned counsel for respondent number 3. As regards the other respondents, within bracket respondent number 1 and 2, the appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of April. List accordingly.
Highly obliged.
Item 5. Item number 5.
Yeah, please, your lordship. Lordship, I'm appearing on behalf of Mr. T. Kolita. Though his name has not been shown, his junior name has been shown. The matter will be taken after some time, your lordship.
Now we issue notice. Heard Mr. D. Mandal appearing on behalf of Mr. T. Kolita, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and order dated 27/1/2025 passed in MSC case number 379/2021 by the Motor Accident Claims Tribunal, Nagaon. Stop. The appeal is admitted. Appeal is admitted. Stop. Let the records of MAC case number 379/2021 be called for from the concerned tribunal. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within a period of 7 days, returnable on 2nd of April. The registry is directed to reflect the name of Mr. T. Kolita as engaged counsel for the appellant in the cause list henceforth.
Lordship,
List accordingly.
perhaps there is an IA of stay. Now in stay, I cannot submit anything.
They will not pass any order now. Will pass on next date. If there is urgency, he will mention.
Oblige, your lordship.
Item 6.
May please your lordship, the present appeal is preferred under section 23 of the rating, challenging the impugned order passed by learned tribunal. Lordship, at this stage, notice may be issued.
What is your name?
U. Bihani.
Heard Miss U. Bihani, learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been who is appearing? Also, Miss A. Gayan, Learned Council, Central Government Council, appearing for the respondent number 1, 2, and 3. This appeal under Section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant Messrs. Vinayak Logistic, impugning the judgment and order dated 30/6/2025, passed by the Railway Claims Tribunal, Gauhati bench in review petition number REV/GHY/40/2019, arising out of original application number OA within bracket 1/GHY/1/2018. Stop. The appeal is admitted. Let the records of the review petition as well as the original application be called for from the Railway Claims Tribunal. You have received the copies.
My lord, copy may be served. Extra copy.
The appellant is directed to furnish the requisite number of copies of memo of appeal along with the annexures to the Learned Central Government Council within 2 days from the date of this order. List on 2nd of April.
My lord, similar order may be passed in item number 7 to 10.
Seven to 10, same order.
Item 7, I'm appealing.
Write the names of Central Government Council. In 8,
H. Gupta. H. Gupta.
H. Gupta. 9, A. Gayan. 10, who is appearing in 10?
My name may be recorded, my lord.
What is your name?
G. Pegu, my lord.
G. Pegu.
EGC.
All Central Government Council. Same order.
7 and 10, my lord.
Same order. In 7 also Girin Pegu and 10 also. Same order, same date.
Much obliged.
Item 11.
May previous matter. The regular first appeal matter. I pray that the appeal may be admitted, records may be called for at least.
Third, Mr. A. Iqbal, Learned Counsel for the appellant. This appeal under Section 96 of the Code of Civil Procedure 1908 has been referred by the appellants impugning the judgment and decree dated 25/11/2025 passed by the Court of Learned Civil Judge Senior Division, Golaghat, in title suit number 12/2025, whereby the suit filed by the present appellant was dismissed. I have gone through the grounds of appeal and heard learned counsel for the appellant. The appeal is admitted. Let the records of title suit number 12/2025 be called for from the trial court. The registry to may issue requisition for the same. Stop. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within a period of 7 days from the date of this order, returnable on 7th of April.
Obligement.
May I please your lordship? Your lordship, in item number 5, I have took instruction. The stay application can be disposed of. I agree to deposit 50%.
Item number 5.
stay may be granted subject to deposit of 50%.
But Mr. D.
Your
Mondal,
lordship, my name may not be recorded.
why? You are
Because
before me.
I am generally appear for claimants. Advocate for the
No, but
applicant.
now you are appearing for Mr. T. Kolita. You are not appearing for claimant in this case.
Yes.
So your name may be recorded.
Instead,
You
your lordship, advocate for the applicant.
heard Mr. D. Mondal appearing on behalf of Mr. T. Kolita, learned counsel for the applicant. This interlocutory application has been filed under order 41 D. Mondal Nam Katinyo. Under order 41 Rule 5 of the Code of Civil Procedure, praying for stay of execution of the execution of the judgment and order dated 27/1/2025, passed in MEC case number 379/2021 by the Motor Accident Claims Tribunal, Nagaon. Learned counsel for the applicant has submitted that the aforesaid judgment has been impugned by the applicant insurance company in the connected MAC appeal number 604/2025. He submits that said appeal has been admitted and notice to the respondent have also been issued. He also submits that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay to the execution of the impugned judgment. Stop. In view of these submissions made by learned counsel for the applicant, the notice to respondents is hereby waived, and this interlocutory application is allowed. The execution of judgment and order dated 27/1/2025, passed by the Motor Accident Claims Tribunal, Nagaon, in MAC case number 379/2021, shall remain stayed during the pendency of the connected MAC appeal number 604/2025, subject to payment of 50% of the awarded amount, subject to deposit of 50% of the awarded amount by the insurance company to the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed.
Hello.
Item 12.
Please, your lordship.
Lord Mr. A.K. Sahiwala.
My lord, I have a submission to make in this. What has happened, my lords, after filing of this appeal, there was a review application filed and the court has partly allowed the review application.
Now you are not pressing for this.
My lord, we have two options now. Either you allow us to amend the appeal or we withdraw and refile it.
Now what is your prayer?
My prayer is, if your lordship allows to amend the appeal, I'll amend and incorporate this as a ground of appeal. That is only limited.
Okay. Lord Mr. A.K. Sahiwala, learned counsel for the appellant. He submits that after filing of the instant appeal by the appellant, who had filed the review application?
Insurance company.
In a review application which was filed by the insurance company, the tribunal has reviewed the judgment
Dated 31/25.
judgment dated
31/2025.
31/2025, which is impugned in this appeal, and therefore he prays that in view of the said development, the appellant may be allowed to amend the memo of appeal, and some time is prayed for the same. The prayer is allowed. the appellant is allowed to amend the memo of appeal. He shall submit an amended memo of appeal before the next date fixed. Let this matter be listed after 17th of March.
Good. Item 13.
May I please be moved? Lordship, this appeal is preferred by the claimant for enhancement of compensation, Lordship.
Heard Mr. A.R. Agarwal, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been preferred by the appellant / claimant, impugning the judgment and award dated 3/3/2025 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MAC case number 454/2022, whereby an award of rupees 19,54,200 was whereby a compensation of rupees so and so was awarded to the claimant appellant. The appellant, in this appeal, is mainly aggrieved with the quantum of the compensation awarded to him. Stop. The appeal is admitted. Let the records of MAC case number. Why?
No problem.
Let the records of MAC case number 454/2022 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice to the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
Item 14. May it please your lordship. Lordship, this is an MSc appeal. And we are aggrieved by the amount of compensation that was granted to us.
What is your name?
R. Ghosh.
Heard Mr. R. Ghosh, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellants / claimants, impugning the judgment and award dated 29/8/2025 passed by the Motor Accident Claims Tribunal, Morigaon, in MAC within bracket death case number 70/2019. The appellants are mainly aggrieved by the quantum of compensation awarded to them by the impugned judgment and award. Stop. This appeal is admitted. Call for the records of MSc within bracket death case number 70/2019 from the concerned tribunal. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
Objection. May I beg to interrupt you, Lord, I have tendered my apology. But if my item was on item number 5, my lord.
We have passed orders.
Lord, my name may be recorded, my lord. I was
We-
very late. I fixed up, my lord.
We have recorded your name.
My lord, much lord. Much.
I hate Mr. T. Kolita.
What's up?
Item number.
Your
Yes.
Lordship, this is an appeal against the judgment and award dated 4/11/2025. And our ground of appeal is that the deceased, Your Lordship, he was a government employee, he was a police constable.
Heard Ms.
Yeah.
A. Biani, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and award dated 4/11/2025, passed in MSC case number 1257/2020 by the Motor Accident Claims Tribunal, Kamrup Metro, whereby the appellant was directed to pay an amount of rupees 81,58,893 along with an interest at the rate of 6% per annum to the respondent's claimant. I have gone through the grounds of appeal and heard learned counsel for the appellant. Stop. This appeal is admitted. Call for the records of MSC case number 1257/2020 from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April.
Your Lordship, there's an IV for stay also.
IA we issue notice. In IA also issue notice.
Much obliged.
Orders, item 16. Item number 16.
As per office note dated, my lord, my knowledge, my lord, the service upon respondent number 3 has not received back. My lord, may I peruse the office note and the last order. Has not received, my lord.
You take fresh steps.
My lord, please necessary, my lord.
Heard Mr. T. Kolita, learned counsel for the appellant. Also heard Mr. A.B. Day, learned counsel for respondent number 1 and 2. On perusal of the office note dated 21/2/2026, it appears that the service report in respect of notice issued to respondent number 3 has not yet been received. Stop. The appellant is directed to take fresh steps for issuance of notice upon respondent number 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31 March.
We will try to take steps by Dusty also.
The appellant is also additionally allowed to take steps for issuance of notice upon respondent number 3 by Dusty mode. Stop. If in the event the appellant is able to serve the notice upon respondent number 3 by Dusty mode, it shall submit an affidavit in compliance thereto on the next date fixed.
My lord, I have a small prayer, my lord, in this case. There is an IA, my lord, which was disposed of
List accordingly.
on 4/12/2024, number 1828 of 2023. My lord, there was an order for deposit of 50%, my lord. To my idea, the same has not been
Yes, perhaps not.
They have
complied
not.
with, my lord. And
You go for execution. If they
my lord, once
don't,
the LCR has come back, my lord, that becomes a little difficult.
no,
because
but if they don't deposit, that
Without-
means there is no stay.
without that LCR being there, the certificate proceeding under Bengal, that my lord, they cannot prepare the case.
Now
record.
what is, you deposit the amount, you have,
I'll take instruction, my lord. Why it has not been deposited, my lord, because.
otherwise they will go for execution.
Yes, my lord. I'll.
21/3, my lord, proceed positively.
And I'll just making a step.
Okay, on the next day.
Praying.
I'm not reflecting it in it.
My lord, I'm just wanted to bring it to the my lord.
Item 17 and 18.
Yes, my lord. My lord, myself for the appellant. My lord, this is an IA filed under Section 5 of Limitation Act, read with Section 14 of Indian Limitation Act, my lord, for delay condonation of 2477 days, my lord. My lord, the grounds for delay in respect of filing the MSc appeal is well
No,
explained
no,
in para number.
no, before you go to grounds, whether notice have been served.
My lord, notice is also served, my lord. The respondent number 2 and 3 is strike out as per order dated, my lord. Uh, 22/10/2025 in civil appeal number 1867/25, which was filed for the striking out the respondent number 2 and 3.
ISO civil appeal number. And upon one,
My lord, IA number 1867/25. This was filed for the striking of the respondent number 1 and 2, and accordingly, the court height order dated 22/10/2025. The respondent number 2 and 3 was strike out, and respondent number 1 was also appeared in the last.
there is no indication
Yes.
that you have taken steps for issuance of notice on respondent number 1.
So, my lord, one date may be given to notice, my lord, and also allow my file additional affidavit delay with day by day explanation.
Why have you not explained in your interlocutory application?
At the time of the filing the IA, it was unaware about of the fact that when the appellant was came to know about of the judgment, because of usually when the amount is deposited and the concerned advocate of the trial informed to about of the payment of judgment, and only such days they came to know. So I want to know exact date when they
So
came to
without
know.
knowing the exact date, why you have filed the delay condonation
Idea
application?
Sure. Exact date is not known to me. I have to take instruction from the appellant.
No. Have you mentioned in your interlocutory application that at that time the date was not mentioned to you, was not known to you?
Actually, yes, I am also mentioned that when the judgment was passed, it was not known to the appellant is mentioned in the IA, my lord.
Heard Mr. B. Ardas, learned counsel for the applicant. It appears that though by order dated 15/9/2023, the applicant was directed to take steps for issuance of notice upon respondent number 1. However, till date, no such notice, no such steps has been taken by the applicant. Why have you not taken steps?
Earlier, when advocate was appeared on behalf of OP number 1, actually, I don't know how did the respondent name is advocate name is not mentioned. My lord, maybe given one chance to issue notice,
No, there is no indication that anybody has appeared.
So, my humble request to my lord may be given one chance to issue notice to the respondent 1, my lord.
No, but you are not complying with the court's order.
Extremely sorry for that, my lord. I apologize, my lord. One chance may be given you, my lord. High Court.
Learned counsel for the petitioner submits that he was under impression that the respondent number 1 has been represented by some counsel. However, no indication to that effect is there in anywhere in the case record. However, for the ends of justice, one more chance is granted to the applicant to take fresh steps for issuance of notice upon respondent number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April, list accordingly.
Highly obliged, my lord.
Item 19.
May it please your lordship. Your lordship, I am appearing on behalf of Mr. T. Kalita, your lordship. He is on lakes in other court. So I pray that if he be taken up after some time, your lordship.
Okay, after something.
Okay.
Item 20.
May please, Lordship, I have taken steps twice, Lordship, but not returned, Lordship. So I humbly pray that I will take fresh steps on all the respondents once again, Lordship, by usual process and the speed post, Lordship. Notice to return unserved or served not return.
No, you have not taken steps. Neither you have appeared before Lawazima court.
Lordship, I have taken steps on first date and second date also on 10/6/24 also I have taken steps, Lordship. But that is not reflected in the documents. So I humbly submit that one chance may can be given. For taking fresh steps on all the respondents. By both ways, Lordship.
Heard Mr. A.R. Agarwal, a learned counsel for the applicant, who submits that the applicant may be granted one more chance to take steps for issuance of notice upon the respondents. The prayer is allowed. Stop. The applicant shall take steps for issuance of notice on all the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
Item 24.
May I please your lordship? According to office note dated 22/2026, respond note services completed upon respondent number 4 and respondent number 1, 2 and 3 have already appeared. So kindly the matter may be fixed for hearing.
Heard.
I am appearing for one.
Miss, what is your name? Miss
S. Pal, appearing on behalf of Mr. S. Datta.
Miss S. Pal, appearing for the learned counsel for the appellant. Also heard Mr. B. Barua, learned counsel for respondent number 1 and 2. And who is for 3?
S.S. Roy.
No one has appeared for respondent number 3. On perusal of the office note dated 20/2/2026, it appears that notice issued to respondent number 4 has been duly served on the said respondent by the process server. Hence, the notice issued to the said respondent is held to be duly served. The Service of notice on all the respondent is complete. The records of the concerned MAC case has also been received, and therefore this case is ready for hearing. List this matter for hearing
My lord, can it be in April, my lord? I am for the claimant, my lord.
in April.
Any date, my lord, after being vacation.
On 28th of April.
Like,
Master oblige, your lordship.
25, no? 20 of April, no?
Lordship, in this case, as per notice note, Lordship, notice note dated 22/26. Respondent number 2 and 3 are not served, and 7 is insufficient address. Others are served, Lordship. Those 2 and 3, Lordship, they are owner and driver.
When have you taken steps?
Steps were taken long back, Lordship.
You take fresh steps.
Lordship, respondent number 2 expired. So his legal heir, we are not aware who are.
Who is the owner?
Who is the owner of a vehicle, Lordship? 3 vehicles are involved in this case. 2 is the owner of the vehicle WB 23.
On what ground you are challenging?
Lordship, 3 vehicles are involved. Charge sheet is filed against those 2 vehicles. Our vehicle is not charged. So
Then notice has to go to them.
So, Lordship, yes, Lordship, but 2 legal heir, we are to confirm.
Find out. Heard Mr. A.J. Saikir, learned counsel for the appellant. Also heard Mr.
B. Bora for
B.
respondent.
Borwa, appearing for respondent number 1. Also heard Mr. P. Bauthakur, appearing for respondent number 4, and Miss L. Sharma, appearing for respondent number 8. On perusal of the office note, it appears that the notice issued to respondent number 2 and 3 have returned without service. It is in respect of respondent number 2, it is stated by the process server that respondent number 2 has expired. Stop. Learned counsel for the appellant has sought for some time to find out about the details of the legal heirs of respondent number 2, so that necessary steps regarding substitution of the legal heirs may be taken up by the appellant. Prayer is allowed. As regard respondent number 5 and 6, who is appearing for 5 and 6? No one.
No, but they are served.
5 and 6. It appears that the notices issued to them have been duly served. Stop. The appellant is directed to take fresh steps for issuance of notice upon respondent number 3 and 7 by speed post, as well as by usual mode, within 7 days from the date of this order, returnable on 8th of April.
I have a prayer, my lord. Registry may be directed to reflect my name. My name is not being shown. B. Bora for respondent.
The registry is directed to reflect the name of Mr. B. Borwa in item number
25, my lord.
B. Borwa as engaged counsel for respondent number
1, my
1 in the cause list henceforth.
lord.
26.
None has appeared for the applicant on call. List this matter again on 5th of March.
Item 27.
Lordship, as per this note dated 21/2, no AD card nor unsubscribed notice of respondent number 2 has arrived.
How many respondents are there?
One is served. Lordship. 2 and 3 is to be served.
Notice you have taken steps in 2024.
Yes, Lordship.
Fresh steps have been. Mr. A.J. Saikya, learned counsel, heard Mr. A.J. Saikya, learned counsel for the applicant. Also heard Mr. N.Z. Chaudhary, appearing for respondent number 1. On perusal of the office note dated 7/1/2026, it appears that the service report in respect of notices issued to respondent number 2 and 3 have not yet returned. The applicant is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April.
Item 28.
My lord, this is first appeal, and this has not yet been admitted.
Who is appearing for the other side?
Lordship, I am appearing for respondent number 2 and 3.
What is the case?
This is for compensation, my lord. I was prosecuted in foreign tribunal without any ground. And purely,
No. What is the case?
the case is that he was prosecuted, my lord, in the foreign tribunal without any ground, without even the allegation that he is a foreigner.
No, in foreigners tribunal, prosecution is
Without any ground, my lord. Only formally it was forwarded by the subordinate of police saying that I am a foreigner, without any ground, material on record.
so you could have challenged this before foreigners tribunal. What happened in foreigners tribunal?
In the forest tribunal, also allowed me as citizen of India, declared me as citizen of India.
Now, against whom you have sought compensation?
Against the government, against the inquiry visa as well as the government, because that did file the allegation without any material on record. And the proceeding was also expert, they did not appear before the before the court.
Why the trial court rejected your prayer?
It is the,
You filed a title suit.
yes, sir. It is at page 6, my lord. It is the limitation I filed the appeal.
What are the grounds which you have taken in this appeal?
Not that on bad faith, the prosecution was taken.
You have anything to say?
Lordship, I think this matter is not maintainable because the lower court had dismissed the title suits because he claimed the compensation against the present respondent who are the government. And he claimed 1.15 crore against his.
In your suit, how you have shown that the government official acted in bad faith?
Because there is no material on record. I have called for the original case record and found that there is nothing against me. I am a government servant, but in the inquiry report it stated I am a day laborer. So the inquiries have never visited my house. It is the case record. Section 15 is not applicable in this case.
Yes. Okay, we are admitting the appeal. Mr.
N.H. Malyavi.
N.H. Mazar Bhuya, learned counsel for the appellant. Also admits, what is your name?
B Deka,
B. Deka. You are
correspondent number 2 and 3.
appearing for your government advocate,
Lordship,
learned government advocate appearing for respondent number 2 and 3. Who is appearing for, though the name of Deputy Solicitor General of India is reflected in the cause list, no one is representing respondent number 1 in this case. No one was found. No one was found. No one for respondent number 1 was found on call. This appeal under section 96, read with order 41 of the Code of Civil Procedure 1908, has been filed by the appellant, impugning the judgment and order dated 26/8/2025, passed by the learned Civil Judge Senior Division, Nagaon, in title suit number 57/19, whereby the said title suit, whereby the suit filed by the present appellant, seeking compensation against the respondent, was dismissed. I have gone through the grounds taken by the appellant in his memo of appeal. I have also heard learned counsel for both sides. This appeal is admitted. Let the records of title suit number 57/91 be called for from the trial court. The registry to take steps for requisitioning the records. Let this case be listed after receipt of the records from trial court on 7th of April.
Item 29.
Yes.
Lordship, with the office note, service report is not shown there. But Posilis Lordship, the engaged counsel has, his name has been reflected in the Posilis.
No. What you said?
Service report.
And thereafter?
In the causeless Lordship.
Names are reflected.
Names are reflected.
Okay. Why they have submitted any wakalatnama? Whose name is?
Some Muzumdar.
P.K. Majumdar. We'll ask registry to verify
Lordship.
and in the meanwhile await for service report. Heard Mr.
Yes.
A. Islam, learned counsel for the petitioner. It appears from the office note dated 28/2025 that the notice issued to respondent number. How many respondents are there, sir?
Sole respondent.
The notice issued to sole respondent have not returned till now, till date. However, learned counsel for the petitioner has pointed out that in the cause list, name of Mr. P.K. Majumdar has been shown as engaged counsel for the respondent. Registry to verify the same and put up a note to that effect on the next date fix. Will you take fresh steps?
Lordship, let us wait for some time.
Okay. Let this matter be listed again on
Short date.
short date. 5th of March.
Item 30.
May I please your lordship? May I please your lordship? Lordship, as per office note dated 21/6/2026, the issuance of notice upon respondent number 3 is completed. And in
Another two?
and in respect of respondent number 2, the notice was answered with remark that addressee cannot be located.
See, somebody has appeared. You are for
Appearing for on behalf of A. Hussain for respondent number 1.
respondent number 1.
Counsel appeared for filing.
What is your submission as regards respondent number 2?
2 is the owner of the vehicle. So this appeal is for quantum of compensation. So he may be strike off.
You are claimant.
The claimant, yes.
Okay. And this, your case was dismissed or it is for enhancement?
This appeal is for enhancement, Your Honor.
Heard Miss A. K. Bhattacharjee.
B. Chaudhary.
Sorry.
B. Chaudhary.
B. Chaudhary, learned counsel for the
Lordship,
just a minute. The learned counsel for the appellant. Also heard Miss, what is your name?
D.R. Ahmed.
D.R. Ahmed, appearing for respondent number 1.
Lordship, we have not received the copy of appeal, main appeal copy.
Okay.
It's up to us.
Appearing for respondent number 1. On perusal of the office note dated 21/2/2026, it appears that wakalatnama on behalf of respondent number 3 has been filed There was a delay condonation application. Yes.
The Lordship that was disposed on 7/11/2025.
That is disposed of, Your Honor, and appeal is also admitted for hearing. LCR is also received.
Has been filed in the connected interlocutory application, and name of Miss R. Rabha is also reflected as engaged counsel for respondent number 3 in the cause list. It also shows that the notice sent to respondent number 2 could not be delivered due to the could not be delivered, and same is returned with a postal endorsement within inverted comma. Addressee cannot be located, comma, return to sender. Learned counsel for the applicant appellant has submitted that since this appeal is directed mainly against the quantum of compensation awarded to the claimant, the presence of respondent number 1 may not be necessary, and hence praise for striking out the same, striking out his name. The prayer is allowed. The name of respondent number 2 may be struck out from the memo of appeal. It appears that the records of the concerned MSC case has already been received, and this appeal is therefore ready for hearing. List this matter for hearing on 5th of May.
Placed.
41.
May I please, your lordships. In this case, my lord, I has been filed for condoning the delay of my lord 396 days for enhancement. My main appeal is for enhancement, my lord. Regarding quantum, only, my lord.
Notice?
My lord, notice, my lord, I have not taken steps, my lord. I may be allowed to take steps, my lord.
Heard Mr. T. Uddin, learned counsel for the applicant, who prays for some more time for taking steps for issuance of notice upon the respondents as directed by this court by its earlier order. Stop. The prayer is allowed. The applicant is directed to take fresh steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of April. The registry shall also issue reminder for requisitioning the records of the concerned MSC case from the concerned tribunal. List.
My name may be shown, my lord, in causes. Yes, I'm.
And sorry, sir. Muftiuddin S. Ahmed. Let the registry is directed to reflect the name of Mr. S. Ahmed as engaged counsel for the applicant
Obliged.
in the cause list henceforth.
Obliged, ma'am. Item 32.
Perhaps the notices service has not completed.
I'm appearing for respondent number 1, minute. Claimant.
Who is the appellant?
Is the insurance company, madam, truck owner, insured with the truck.
United India companies also.
Who is number 3?
Number 3 is this one, driver,
One is the claimant. Madam.
claimant,
Number 3
is the driver.
notice has returned without service.
If required, we'll take fresh.
Okay. Heard Mr. A.K. Sahewala,
Huh?
learned counsel for the applicant. Also heard Mr. S. Nath, appearing for respondent number 1. On perusal of the office note dated 23/10/2025, it appears that notice issued to respondent number 2 has been served on and has been received by one of the employee of the respondent number 2 insurance company. Stop. The notice is issued to respondent number 2 is therefore, held to be duly served. As regards this respondent number 3 is concerned, since the office note shows that the notice issued to the said respondent has returned without service, the applicant is directed to take fresh steps for issuance of notice upon the said respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
33 is also similar, arising out of the same case.
33.
Itu kan asal next to asal nothing.
32 also I am appearing for respondent number 1. Minute. Claimant.
Fresh steps. Heard Mr. A.K. Sahewala, learned counsel for the applicant. Also heard Mr. S. Nath, learned counsel for the respondent number 1. Office note dated 5/2/2026 shows that notice issued to the respondent number 2 and 3 have not been served. Stop. The applicant is therefore directed to take fresh steps for issuance of notice upon the respondent number 2 and 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on same date, 7th of April.
7th?
7th of April.
April.
Item 34.
My lords, can I pray for one small, on the last matter which appeared, can it come up on 20th rather than on 17th? If your lordship allows.
Which one?
Item 12, ma'am.
Item?
12. Lordship had granted 17th. Can it be on 20th if at all lordship allows?
Who appeared for other side? No.
Nobody.
Okay. When do you want?
20th, 20. Same, 20th.
Item number 12,
20th March.
20th. Munmun of Kubo.
March of
1044.
May I please your lordship, this is a delay contestation, delay is only 8 days.
You're opposing?
No one. Please.
Heard Miss B. Sarkar.
Your lordship,
Yes.
there is a stay petition.
First, let me condone the delay. Heard Miss B. Sarkar, learned counsel for the applicant. Also heard Mr. J. Laskar, learned counsel for how many respondents? Learned counsel for the sole respondent. This interlocutory application under Section 5 of the Limitation Act has been filed by the applicant, praying for condonation of delay of 8 days in filing the connected regular first appeal, whereby the applicant has impugned the judgment and decree dated 6/8/2024, passed in title suit number 70/2020. Title suit number 70/2017. Stop. Learned counsel for the applicant has submitted that the grounds for delay has been stated by the applicant in paragraph number 6 of the instant interlocutory application.
6, 7, and 8.
6, 7, and 8. Learned counsel for the respondent has submitted that considering the grounds shown by the applicant, he does not have any objection if the delay is condoned. Stop. Considering the submissions made by learned counsel for the parties as well as grounds shown by the applicant for the delay in approaching this court for filing the connected appeal within the prescribed period of limitation, this court hereby condones the delay of 8 days and allows this interlocutory application. The registry is directed to register the connected regular first appeal and list the same for admission after a week on a date to be fixed by it. You have filed any execution case?
Yes, my lord.
Yes,
Till today, the IA for stay has not been numbered, my. Let the matter may fixed for.
Where is I?
IA
85, serial number 8.
serial number, it has not been numbered
Lordship,
till today. my.
serial 8575.
No, let it be listed.
Your lordship,
We
next
are-
22/3. Execution order.
Not on
Extended.
11/8/25 notice was issued, my lord. They could have mentioned, my lord. Let it may be
Until
posted.
next date, your
It
lordship.
may be
When is the next date for execution
3.
case?
2, 3, my lord. It may be posted next day. My lord.
Until then, your lordship kindly. Status
My
quo.
lord, the IA has not numbered. How lordship can pass an order?
Only status quo, your lordship.
Status quo, how my lord? The delay condonation petition, whether there is any prayer, my.
Execution, if execution proceeding is finished, then what is the function of this
Finished, my lord.
stay petition or appeal?
एक तारीख है, 2 तारीख. No, registry to list the registry to register the connected regulars first appeal and list the same for admission on 2nd of March 2023 along with the connected interlocutory application. Till then, what is the execution case? You file objection.
Written
My lord, let
stipulation.
it be posted, my lord, without, my lord, the numbering of that case, my lord. And if they are so much urgency, they could have mentioned it before the court, my lord.
But you are not denying that there is an
No,
execution.
execution, my lord, that part, my lord, even 15 today, I have not furnished with the IF for stay and first appeal also, my lord. Let those things be served to me, my lord. And it may be posted on the second, my lord.
We will take it up on second.
My lord.
Second,
Second,
the posting, the
no,
execution court.
They can
the
do it,
learned counsel for the applicant is directed to furnish the copy of memo of appeal along with annexures as well as the copy of the interlocutory application filed by the present applicant to the learned counsel for the respondent. When will you furnish? Today itself. Today itself. List on second.
My lord, on second, my name may be shown, my lord, because
The name of Mr. J. Laskar may be shown as the engaged counsel for respondent when the connected appeal would be listed on 2nd of March.
Highly object.
Item 35.
May I please your lordship? My lord, in this interlocutory application, my lord, in connection of FAO, my lord, there is a petition. There is a delay of 211 days, my lord, in filing this appeal, my lord. Against the final order.
Notice is served.
My lord, I have taken steps for service of the notice common to the respondent number 1, my lord. And
When have you taken steps?
my lord, I
12:25. Okay. We'll call for the heard Miss B.R.A. Sultana, learned counsel for the applicant. On perusal of the office note dated 21/2/26, it appears that the notice issued to the sole respondent has not yet returned. Stop. It appears that the applicant. No, you have not taken by speed post.
my lord.
Only by usual mode. You take steps by speed post. Last line. It appears that the notice issued to. No, it appears that the applicant has only taken steps for issuance of notice by usual mode. Stop. The applicant is directed to take fresh steps for issuance of notice upon the respondent by speed post within a period of 7 days, returnable on 2nd April.
Item 36.
Yes, my lord. My lord, this I 3784/25 is filed. My lord, to given direction to the appellant to deposit a 50% from the awarded amount, my lord.
Lordship, we have filed an objection to their petition, your lordship, but that is not on record, your lordship.
Is there any stay?
No, your lordship.
You have
The
prayed?
Carnival date, there was a stay.
No.
21/20/26, but that's not on record, your lordship.
Have you filed any stay?
Yes, your lordship, we have filed our stay petition.
Stay was without any condition.
Date till returnable date, your lordship. The stay was granted.
My lord, stay may be granted with the condition to deposit a 50% from the awarded amount with a bond, my lord. As my lord,
You deposit 50%.
Lordship, we have filed our objection, Your Lordship. My prayer is that let it be tagged, Your Lordship, after that this petition may be heard.
My lord, we may be filing a bond, my lord.
Liability
You
in
have,
this case, Your
you
Lordship,
have filed objection against in this interlocutory
Your
appeal.
Lordship, against this I. We
Okay.
have filed our objection, Your Lordship.
And what happened to another? What is the I number? Present I number?
Their I number is 3784 of 2025 to be.
What happened to I number 481? Putul, I number 481. We can dispose of both the I's together after considering your objection.
Objection, yes. Your
Objection. You are for?
My lord, I am appearing for response number 3 and 4. Brave, my lord.
In I number 481 लिखिबो. Heard Miss P. Bothakur, learned counsel for the applicant. This I is for stay.
Stay, Your Lordship.
Heard Miss P. Bothakur, learned counsel for the applicant. Also heard Mr. B. R. Das, learned counsel appearing for respondent number 1 and 2, as well as Mr.
P.S. Bhattacharya.
P. S. Bhattacharya appearing for respondent number
P and
3 and 4. Who is 5?
Respondent number 5 is the owner of the scooty, Your Lordship. Our contention is that we are the insurer of the scooty, Your Lordship, not the grief, against which there was allegation of rash and negligence, Your Lordship.
So you have not taken steps for issuance of,
We have taken steps, Your Lordship.
but there is no office note.
Lordship, as per office note dated 6/6/2025, Your Lordship, respondent number 5 was duly served. I duly served.
6/6/2025 in the MAC appeal.
Lordship, 6/6/2025. Yes, Your Lordship, in the main appeal.
On perusal of the office note dated 6/6/2025, it appears that notice issued to respondent number 5 has been duly served. Stop. It also appears from record that by order dated 21/2/2024, this court directed that the execution of impugned judgment and award passed in MSC case number 15/2022 shall remain stayed till next returnable date, that is till today. Stop. In the meanwhile, the claimants herein have filed another interlocutory application, which has been numbered as IA civil number 3784/2025, whereby the claimants have taken stand that they don't have any objection to grant of stay to the stay of the execution of the impugned judgment and award, subject to payment of 50% of the awarded amount by the subject to deposit of 50% of the awarded amount by the insurance company / appellant. Ms. P. Thakur, learned counsel for the insurance company applicant has submitted that the insurance company has filed a written objection against the interlocutory application filed by the claimants, that is IA number 3784/2024. However, the said written objection is not on record. She prays for directing the registry to place the written objection filed by the insurance company along with the said interlocutory application. Stop. Since both these interlocutory applications are connected to each other, these both of them shall be taken up together for consideration and disposed of on the next date fixed.
My lord, can it be fixed on 11 March?
Okay, next date fixed. In the meanwhile, the registry is directed to place on record the written objection filed by the insurance company. List this matter on 11th of March.
Okay.
In main appeal, heard Miss P. Thakur, learned counsel for the appellant. Also heard Mr. B. R. Das, learned counsel for respondent number
1 and 2, my lord.
1 and 2. As well as Mr. P. S. Bhattacharjee, appearing for respondent number
3 and 4.
3 and 4. The notice issued to respondent number 5 has been duly served as appears from office note dated 6/6/2025. This case is therefore ready for hearing. List it for hearing when?
Same date, my lord, 11/3.
Finally heard, your lordship, since LCR has.
Yes,
also-
yes.
Your lordship.
On 11 March.
Yes, yes, my lord.
Oh, nice.
Highly obliged.
May I please, your lordship? Lordship, I have a small prayer, lordship. Lordship, can the matter be adjourned for the day, lordship? Because Mr. Ghoshi is not well. He has gone for a doctor's appointment.
Who, Mr.
Yes, lordship, Mr. Ghosh.
My lord, on last occasions also due to the
Lordship,
difficulties.
only
he
for
was
today,
absent,
lordship.
my lord. But for the medical ground, I have no objection, but the
Lord.
date may be fixed on 5th of March, my lord, because my lord, this is a second review petition against an order of review. The case is fixed for maintainability of the petition, my lord.
Last
It is
time
not
it was-
maintainable, my lord, the petition, review petition against an order of review, my lord. Barred by order 47 rule 9 mil.
No, in RSA was dismissed.
Yes, my lord. RSA was, my lord,
Dismissed. Then a review application was filed.
yeah, allowed, my lord,
Review application was
allowed, my lord.
review application was allowed. Against that review application, again another
The
review.
review application.
Another
That is not maintainable.
Yes, my lord. Order 47
Lordship,
rule
on
9 is
next date.
clear, my lord. On 5th, my lord, kindly make.
Heard Miss F. Ahmed, learned counsel for. Who is the review petitioner? You are learned counsel for the. Why this interlocutory application?
My lord, it was an application for implementing the notary, my lord. Because well, they have now placed a document, notarized document, that has been my lord, forged document, my lord, for which the notary was, my lord, application for.
Learned counsel for the applicant / review petitioner. Also heard Mr. M.Z. Kadir, learned counsel for the respondent. Learned counsel for the petitioner prays for an adjournment on the ground that Mr. S.K. Ghosh, the learned counsel for the petitioner is indisposed. Considering the ground shown by the learned counsel, the prayer is not objected to by the other side also. Hence, same is allowed. Let this matter be listed on 5th of March.
Obliged.
Obliged.
Item 39.
This case, there is a delay of 220 days. They file objection. Today I have filed lordship. So matter may not be on record.
Objection is not on record.
Not on record. Today I have filed lordship.
Let it be brought on record.
Lordship.
Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr. What is your name?
J. Abbas, lordship.
J. Abbas, learned counsel for the respondent, who submits that the respondent has filed a written objection against the prayer for condoning the delay made by the applicant. However, same is not placed along with this interlocutory application. Therefore, he prays for bringing the same on record. Sub-registry is directed to place the written objection filed by the respondent along with this this interlocutory application on the next date fixed.
6th of
List this matter on 6th of March.
Can it be on 10th, lordship?
10th of March.
Obliged, lordship.
Item 40.
So,
I'll pass over for time being.
What is the matter?
I have filed an IA for substitution of the guardian of the minor. Father was representing the minor in the original MSCT appeal case and he died. So mother, I filed an IA praying for to substitute the guardian. Now mother wants to substitute.
Who is the claimant?
Payment was Tafir Ali. He was minor at the time.
He is still minor.
Minor is 16.
We may allow this application.
Only
Okay. Heard Miss A. Barua. Heard Miss A. Barua, learned counsel for the applicant. Also heard Mr.
L. Deca.
L. Deca, learned counsel for respondent number
2. Insurance company.
Respondent number 2, insurance company. But who is respondent number 1?
one expired order has been passed in the MSCT appeal case.
Since
Owner.
stop. Since in the connected MSc appeal 52/2023, the case has been proceeding ex parte against respondent number 1. The notice to respondent number 1 is waived. This application under Order 23, Rule 4, read with Section 151 of the CPC, 1908, has been filed by the who is Tafir Ali?
Injured. He is the appellant.
By the applicant for substituting the guardian of the applicant in the guardian of the applicant, Mohammed Mohar Ali alias Moharuddin, who was till now the guardian and was the father of the injured minor applicant, and who has expired on when he has expired?
28/7/2025.
Expired on 28/7/2025. The prayer is made for substituting the earlier deceased guardian with the mother of the present applicant, namely Pul Banu. Who is the mother?
Pulbano.
Fulbano. Since
In the death certificate, it is reflected.
that certificate is there, but where is the
The name is reflected in the death certificate.
Fulbanu's name? Where?
Uh, uh, in the columns, name of wife of the disease, Fulban. Left,
Which column?
in the column, name of husband slash wife, Fulban.
Sixth line, fifth line,
Okay.
in the middle.
Learned counsel for the applicant submits that the present that Fulbanu is the mother of the injured minor applicant, as would be apparent from the death certificate, wherein her name has been reflected as the wife of the deceased, namely Maharuddin, who was the earlier guardian of the applicant / appellant. Considering the materials on record, as well as submissions of learned counsel for the parties, the prayer is allowed. The mother of the minor applicant is allowed to be shown as his guardian in the memo of appeal of the connected MAC appeal number 52/2023 in place of his deceased father, Muhammad Maharali, alias Muhammad Maharuddin. This interlocutory application is accordingly disposed of. The applicant shall submit an amended cause title in the connected appeal within a period of 2 weeks from the date of this order. List the matter accordingly. This interlocutory application is accordingly disposed. We have allowed
That substitution.
substitution after 2 weeks.
Can we fix it?
Fix a date, 23rd of March.
It's order 32.
Oh, sorry, order 23, order 32. Order 23 jot koisu nohoy. That order 32. Order 32 rule 4.
Item 41. Mr. Lordship. Lordship, we have filed this IA to substitute the legal heirs of respondent number 1.5, who have expired on 3/12/2025.
It is within the period of
Yes,
limitation.
It is
Any objection?
No. I have instruction to appear on their behalf, madam.
Okay.
The legal heirs are reflected in page number 8.
Heard Mr. Z. Mukit, learned counsel for the,
Lordship, W. Hawk on behalf of Jet Mukti.
sorry, heard Mr. W. Hawk,
On behalf of Jet Mukti.
learned counsel for the applicant. Who expired?
1.5, my lord. Respondent number
Learned counsel for the applicant / appellee. Also heard Mr. What is the name?
M. Setia.
M. Setia, appearing for
For my lord, 1.2, 1.9, 1.11, my lord.
appearing for the legal heirs of
And 1.5. I have instruction to appear on their behalf.
deceased respondent number 1.
1.5.
Who expired?
1.5.
1.5, Lordship.
Deceased respondent number 1.5. Also heard Mr. M. Das appearing for
1, 1, 1, 3, 1, 4, 1, 6,
17, 18, 18A, 18B, and 110.
Okay. This application under section 22, Rule 4 of this Code of Civil Procedure 1908 has been filed by the applicant/appellant in connection with the connected testamentary appeal number 2/2010, praying for allowing the appellants to substitute the legal heirs of respondent number 1.5, namely Hazira Begum, who had expired on 3/12/2025. Stop. Learned counsel for the applicant has submitted that the present application for substitution of legal heirs has been made within the period of limitation, within the prescribed period of limitation. Learned counsel for the respondents have also not opposed the prayer for substitution, hence the said prayer is allowed. The accordingly names of
Legal heir of 1.5.
legal heirs of 1.5, namely Qadrul Islam, number 1. Number 2, Farhana Yasmin. Only 2 legal heirs are allowed to be substituted in the connected testamentary appeal in place of deceased respondent number 1.5, as respondent number 1.5 within bracket A and 1.5 within bracket B. The applicant shall file the corrected cause title of the memo of appeal in the connected testamentary appeal within a period of 1 week from the date of this order. List the connected testamentary appeal accordingly. This interlocutory application is accordingly disposed of.
Lordship, can we fix a date, Lordship, because this is the 2010 matter.
23rd of March.
Of like.
Item 42. We have for respondent.
May I be your lordship? Well, the matter has been listed to consider IA number 240 of 2026. My lord, we have filed this petition for disbursal of the 50% of awarded amount already deposited by the insurance company.
Any objection?
Lordship, I have no objection subject to an indemnity bond, your lordship, since we have made this appeal both on quantum as well as liability, your lordship.
All right, my lord.
Subject to an indemnity.
Mr. J. Molla, learned counsel for the applicant, IA 240. Also at Ms. P. Borthakur, learned counsel for the respondent / insurance company. This application, this interlocutory application has been filed by the applicants / claimants in connection with the connected MAC appeal number 561/2025, praying for directing the opposite party's insurance company to deposit, praying for directing the registry of this court to disburse the 50% of the awarded amount which was deposited by the insurance company before this court in pursuant to the order dated 15/12/2025 passed in IA Civil number 4056/2025 as a condition for grant of stay of execution of the impugned judgment and award. Stop. Ms. P. Bhattakur, learned counsel for the insurance company, submits that the insurance company does not have any objection provided the applicant furnishes an indemnity bond to the effect that they shall return back. You are also challenge liability.
Yes, Your Lordship, both quantum as well as liability. Your
Return back the said amount in the event of allowing of the appeal and in the event of any such direction by the court. Stop. Considering the submissions made by learned counsel for the insurance company as well as other materials available on record, this interlocutory application is allowed. The registry is directed to disburse the 50% of the awarded amount deposited by the insurance company before it in person to this court's order to the applicants. Who is the applicant? Three.
My lord, there are three respondents. We are for respondent number 1, and she has appeared, my lord, she has appeared for respondent 2 and 3.
All are claimants.
All are not originally, only respondent 1 was the claimant in the claim petition before the MSCT. Subsequently, the MSCT made them respondent. Number 2,
and
MSCT.
And whether any award has been passed in their favor also.
No, my lord, no, because my lord, the award cannot be passed in their name because she is the owner of the vehicle involved, offending vehicle.
Okay.
That's why she cannot claim compensation. Hence, my lord, our simple prayer is that respondent 1 may be allowed to receive the amount. She has no objection, perhaps.
What is the name of respondent number 1?
Respondent number 1 is, my lord.
Tuhina Yuhi.
Yes, my lord, Tuhina.
To the claimant.
Yes.
Namely, Tuhina Yuhit after proper verification. Stop. Uporot ek line likhibo. Miss, what is your name? NH ANH Pom, learned counsel for respondent number 2. Two and three, namely Sabita Begum and Bulbul Hussain.
Yes.
Does not raise any objection to the prayer made by the applicant. Ye upar likhna. This interlocutory application is accordingly disposed of. In appeal,
The main Lordship office notes, as per office note dated 16/2/2026, AD card has not been received in respect of respondent number 2 and 3, but Your Lordship, respondent number 2 and 3 has already entered appearance. So service is completed upon the respondents. But LCR is not there, Your Lordship.
heard Miss P. Bhattakur, learned counsel for the appellant. Also heard Mr. J. Molla appearing for respondent number 1. As well as Miss N.H. Form appearing for respondent number 2 and 3. Stop. The appearance of parties in this appeal is complete. However, the records of the MSC case number 2393/2019 has not yet been received by the registry. Issue reminder for the same. List this matter again after on 2nd of April after receipt of the aforesaid records.
Item 43.
May it be please, your lordship. Lordship, this interlocutory application has been preferred for condoning the on days in preferring a matrimonial appeal, lordship.
Will issue notice.
Yes, lordship.
Heard Mr. S.R. Borua,
Lordship.
learned counsel for the applicant. This application, this interlocutory application has been filed by the applicant Junmoni Bej Borua. What is the case?
Lordship,
So if delay can be condoned. There is no liability, breach of
You-
liability. Lordship.
You take the consent.
No, Lordship.
Insurance company is conceding if first issue notice.
Okay, Lordship. No problem.
Heard Mr. A.R. Agarwala, learned counsel for the applicant. This application, this interlocutory application has been preferred by the applicant, praying for condonation of delay of 6 days in preferring the connected MAC appeal, whereby the judgment and order dated 3/11/2025 passed by the Motor Accident Claims Tribunal, Gwalpara, in MSC case number 172/2020 has been impugned. Issue notice to the opposite parties. The applicant shall take steps
Only
for
speed post, Lordship.
issuance of notice upon the opposite parties by speed post, as well as by usual mode, within 7 days from the date of this order, returnable on 31st of March. This
Item 45.
Lordship, here is a similar matter, delay of 145 days. So notices will be.
Your Lordship,
you are for
appearing for respondent number 1.
payment.
Yeah, claimant.
You are opposing
Yeah,
or
we
conceding.
have a objections, Lordship. We will file a objections on next date.
Okay, let them.
Kindly affirm the server notice upon us.
Heard Mr. S.P. Sharma, learned counsel for the applicant. Also heard Miss, what is her name?
B. Datta.
D.
B. Datta.
B. Datta, learned counsel for respondent number 1 claimant. This interlocutory application under Section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condonation of delay of 145 days in preferring the connected MAC appeal, whereby the judgment and award dated 16/1/2025 passed in MAC MSC case number 951/2018. What is this miss case?
Lordship, there should not be any miscase. There should be one I.
Has been impugned and passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, has been impugned. issue notice to the opposite parties. Since Miss B. Datta has appeared for opposite party number 1, no formal notice need to be issued to the said party, said opposite party. However, as regards opposite party number 2 is concerned,
2 and 3, Lordship. 9 there.
2 and 3, no, okay, 2 and 3. She can appear for 2 also.
No, because she is appearing for claimant and 2 is for owner.
Who is the husband of the claimant? No, no.
OP1, yeah, OP1, 2.
It appears that 2 is the husband.
The same family member.
You take instruction whether you
OP1 and 2.
you are sure.
Yeah.
Learned counsel for the. You have filed wakalatnama.
Yeah, this morning, we will file the wakalatnama. This morning we filed the wakalatnama. That's why our name
But
is.
you have filed a wakalnama from respect for 1 only.
Yeah, I don't know actually.
Learned counsel for the opposite party number 1 may take instructions from opposite party number 2 on or before next date fixed as to whether she would be appearing on behalf of opposite party number 2 also. The applicant shall take steps as of now only against opposite party number 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st of March. Learned counsel for the opposite party number 1 prays for allowing the opposite party number 1 to file written objection against the prayer made by the applicant in this interlocutory application. The prayer is allowed. List accordingly.
Item 46.
Made to listed for the first time, my lord. Delay, my lord, 349 days. Notice may be.
Heard Mr. T. Kolita. Learned counsel for the applicant. This interlocutory application has been filed by the
Next one.
applicant insurance company under Section 5 of the Limitation Act, praying for condonation of delay of 349 days in preferring the connected MAC appeal, whereby the judgment and order dated 30/8/2024 passed in MSC case number 15/2020 by the Motor Accident Claims Tribunal Dibrugarh has been impugned. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of April.
Timing item 19.
Made to the lordship.
Iman?
Oh, my lord, here is a delay of my lords. 1698 days.
I'm appearing for respondent number 1, 2, and 3.
You're opposing?
No, we have no objection.
Okay. Heard Mr. T. Kolita. Learned counsel for the applicant. Why there are 2 MAC appeals?
My lord, McApeel is 1, my lord. IA is 3 IAs, my lord. Correct, so the 3 IAs.
So the order has been
Main appeal is
IA 683 dio. IA 455.
no, this one 455, my lord. This is only registered, my lord. Registered, not perhaps registered, my lord.
Mr. T. Kolita, learned counsel for the applicant. Also admits
Bidatta.
B. Datto, appearing for respondent number
1, 2, and
1, 2, and 3 / claimant. This, where is the IA? All orders are passed in appeal, which is yet to be registered. No, ठीक है, ठीक है sir.
Last order, my lord, last order was on 10/2/25.
This appeal, this interlocutory application has been preferred by the insurance company. There is a huge delay.
Delay, my lord.
You have explained that delay.
Yes, my lord, because my lordship may see, paragraph 4, judgment was passed on 10/3/2016, my lord.
This
Subsequently, my lord, review was filed and review was pending, and during that review period, my lord, COVID pandemic, there is a COVID pandemic, my lord, for which the review petition was disposed very lately. Then review petition was dismissed, filed by us, that review was filed by us, then we came up for appeal, my lord.
When the review was decided?
Yes, yes. My lord, it was rejected on 10/10/22. 10 October 22, my lord.
Still there is delay.
Yes, my lord. Yes, my lord. In spite of the fact that the COVID period came, my lord, in between, my lord.
No, in between COVID period came.
Yes, my lord.
Thereafter review application was disposed of.
Disposed of.
Thereafter you made again this much of delay.
My lord, yes, the appeal was filed on, my lord, 9/1/23. Delay, review was dismissed on 10/10/22, my lord. Thereafter 9/1/23 only, my lord. There were 2 months in between, my lord.
क्या लिखा? Insurance company applicant praying for condonation of the delay of 1698 days in preferring the connected MAC appeal, wherein the judgment and order dated 10/3/2016 passed in MSC case number 2036/2011 by the Motor Accident Claims Tribunal, Kamrup Metro number 2 has been impugned. Learned counsel for the applicant has submitted that the delay in preferring the connected MAC appeal has been caused mainly due to the fact that the insurance company, after passing of the impugned judgment and award, had preferred a review application before the Motor Accident Claims Tribunal. Where is the statement?
My lord,
the said review application
yes, my lord.
was registered as
Para 6.
MISJ case number 6/2021. And it was finally disposed of only on 10/10/2022.
And in between, my lord, record was misplaced, my lord. Lordship may kindly see page number 22. I have annexed the order sheet, my lord. The review miscase was misplaced. That is reflected, my lord.
He further submits that during the pendency of the review application, the miscase number
Page 22.
6 of 2021 was misplaced.
Order dated 31/5/90.
When it was traced out,
Then, my lord,
he submits that he submits that the applicant has explained the cause of delay in preferring the connected appeal beyond the prescribed period of limitation in paragraph number 7, 8, 9,
10, my lord, up to 10.
and
my lord.
10 of the instant interlocutory application. He submits that the reasons stated by the applicant in those paragraphs may be regarded as sufficient cause, and the prayer for delay, condonation of delay may be allowed. On the other hand, Ms. B. Datta, Learned Counsel for respondent number 123/claimant, does not raise any objection against condonation of delay, considering the grounds stated in the interlocutory application. Since the claimant respondent has not, what is your ground in appeal?
My lord, basically, my lord, the pleading was against us, my lord. And in fact, 2 vehicles were involved in the accident. And subsequently, the police case registered against us culminated in laying down charge sheet against the other vehicle, my lord. That is because there was no other evidence apart from the pleading, my lord. Only the Form 54 was there before the member MSCT, my lord. Subsequently, when the charge sheet was laid down, my lord.
Till now, the claim amount has not been paid.
No, my lord, no.
क्या लिखा last? Has not raised any objection against the objection against the prayer made of the applicant, notice to the respondent opposite parties number 4 and 5, who are the driver and owner of vehicle bearing number AS02E 4825 is hereby waived. Stop. After considering the grounds stated by.
May I interrupt, Lordship? Lordship, in fact, they have received the notice or office not.
In this case.
Yes, madam.
Okay.
17/6/23. 17/6/23.
4 and 5. 4 and. No, this line. Stop.
Lordship, 17/6/23. Office not.
After going through the submissions made by learned counsel for the parties, as well as going through the reasons for delay in approaching the court for filing the connected MAC appeal, as shown in the paragraph number 6, 7, and 8 of the instant interlocutory. Nice. 6 to 10. Paragraph number 6 to 10 of the instant interlocutory application. কি লিখলো একটু পড়কson?
After going through the solutions made by the party that going through the reasons for delaying approaching the court for filing connected MAC appeal as shown in the paragraph number 6.
This court is of this court is of considered opinion that the said reasons may be regarded as sufficient cause which prevented the applicant in approaching this court within the prescribed period of limitation for filing the connected appeal. Accordingly, the delay of 1698 days in filing the connected MAC appeal is hereby condoned, and this interlocutory application is allowed. Registry is directed to list the connected MAC appeal, register the connected MAC appeal, and list the same for admission on the when.
My lord, very short date may be given if it's a long case, already delayed, my lord. Lordship may kindly, if it possible, my lord, Friday next, my lord, next week, my lord, 6th, my lord.
On 6th of March.
6th of March.
6th of March.
Item 50. Much.
May it please the lordship. My lord, IA number 567 before this honorable court is basically, my lord, an IA filed by the
Government will be required.
my lord, government is there. My lord, my lord, let me. Other attendant, please. Other attendant, please. Sorry, my lord, the appeal in this case has already been.
You are representing?
Number 6, my lord.
My lord, if I may.
No, before you submit.
My lord, no problem.
Let me make sure that parties are represented. Respondent number 6, other respondent?
My lord, notice has been issued. That is what, my lord, if I may take 1 minute of the time of this honorable court, my lord. Appeal was admitted, my lord, and it was admitted on 9/2/2026, page number 39, my lord, for a moment.
Of this interlocutory application?
Yes, my lord, the appeal has been admitted already. Statutory appeal under section 54 of the alia Act, my lord.
Okay.
So I am just praying a stay of the impugned order, my lord, in this case.
No, impugned order cannot be stayed. Execution have to be stayed.
My lord, please.
Is there any execution?
My lord,
For that you have to convince the court that execution case has already been filed, which is required to be stayed in their absence. Such is the urgency.
Lord, if I may, my lord, on that case.
Yes.
My lord, what has happened in this case is this, my lord. There are another parallel proceeding going on before the writ side of this honorable court, where the entire issue, who is supposed to pay, is been determined by the writ bench of this honorable court.
Decided.
Is in the process of decision, my lord. That is what I was trying to indicate, my lord. So, my lord, for a moment, we'll turn to page number 47 onwards. For a moment, my lord, then I'll take this honorable court through. And before that, if my lord may, I can draw the attention to this honorable court at page number 45. 45 is the order of that writ proceedings which is going on, my lord. Now, the crux of that writ proceeding is this, my lord, that the case was filed, my lord, page number 42. I'll just show the parties 2 minutes, my lord. Page number 42 for a moment, my lord. So the writ proceeding has been initiated surprisingly by the state of Assam, that is respondent number 6 in this case. Where the state of Assam is basically asking a writ of certiorari against an LA judgment, order of an LA court. State of Assam is asking if they are not supposed to pay the money has to be paid by the respondent number 7 or respondent number 6. That is, my lord, Union of India or the public office, that is the IIT, director of the IIT. So there were bundle of LA cases which have been filed by the respective parties.
This is for acquisition of land.
Yes, my lord.
In
Precisely.
IIT Gauhati.
Precisely, my lord. When the land was acquired, my lord.
Still the compensation has not been paid.
I'll apprise this honorable court and I'll take this honorable court through what has happened actually. IIT Gauhati was never a party to this proceedings at any point of time before any other forum. Only in this case, that is 83 and 84, which is the judgment of the reference court, IIT Gauhati for the first time is made party to the proceedings of an LA case. Before, in all of the cases, my lord, the government of Assam was the party, because in this case, admitted position is this, that the government of Assam is an appropriate government in this case. Government of Assam in this judgment has admitted this fact, my lord. I'll show. There is no, but just to give a flavor, my lord, what has happened. So the land was acquired. My lord will see, if my lord wants to see that, para number 4. Par contra, the same judgment, my lord, same the WBC 92 of 2023. Par contra, Mr. R. Bodpujari, learned counsel of the petitioner, submits that though in terms of section E of Land Acquisition Act, in the present context, state of Assam shall be the appropriate government. For a moment, my lord, I'll stop here. The entire liability under section 3E and 3F, the public purpose, my lord, rounds around who is the appropriate government. The notification in this case was issued, land were acquired by the state of Assam. IIT was not in existence at all on that particular day. But because there was a finding, which my lord will find in page number 23 of my appeal, my lord. Page number 23 for a moment, my lord. And 27 thereafter, my lord. Straightway, I will take this honorable court, page number 27, para number 11. How IIT has been made party. The convoluted interpretation of public purpose. Page number 27, my lord. My lord is with me? Page number 27. Section F describes public purpose.
Which para you are reading?
My lord, I'm so sorry, my lord, para number 11.
Yes.
It is, I am reading the reference judgment. Section 3F describes public purpose, for which land can be acquired under the Land Acquisition Act as per section 3F6 of the land can be acquired for the purpose of carrying out educational institution and also for the other scheme sponsored by the government. IIT is not that way. On careful perusal of the above provision of law reflects that public purpose land can be acquired in and payment in respect of the said land has to be made by the beneficiary of the acquisition or by the government. In the instant case, IIT Gauhati is the beneficiary as the land has been acquired by the state government for the purpose of establishing IIT Gauhati. As such, in my view, IIT Gauhati is a necessary party for the purpose of disposing of the reference proceeding. I'll pause here for a moment, my lord. The entire logic why IIT was made party is convoluted in a manner that it said you are the beneficiary because land was acquired for your own benefit. My lord is aware, IIT is an engineering institute, my lord. It doesn't create any fund of its own. It is fully founded by ministry, that is the Union of India. And for that reason, my lord, this writ petition was filed. Writ petition number 92, which I have just shown. Now, my lord, in the writ petition number 92, state government was asking who should pay the money. What our writ side has, the court has done, court has asked there has to be some kind of a mutual settlement and directed the parties, it is state government and the central government, to ascertain how much money they have to pay.
No, why writ petition when there is a appellate provision?
My lord, that is for the state of Assam to answer. That is for the state of Assam to answer, my lord. They have filed this writ petition. They have filed this writ petition, and the my lord Justice Borua had commented on the first day itself. No such surety can be there. Now, my lord, I'll just take 2 minutes. My lord, I'll just show what has transpired. Then, my lord, will turn to page number 43 and 44. My lord, can just turn 45. Learned Mr. A.B. De, Learned Standing Counsel of IIT Gauhati. I'm so sorry, my lord. Page number 45. Hari, my lord, I made a mistake, my lord. I'm sorry, my lord.
Don't make mistakes. We'll hear you leisurely
My lord.
after lunch at 2.
My lord, please.
We'll continue at 2.
My lord, please.
Judgment, no, or afterwards.
It will be uploaded. You see it tomorrow. Tomorrow.
Absolutely.
Item 49.
Much obliged.
For reasons stated in the judgment, this appeal is also dismissed.
Both are dismissed.
Yes.
One goes in my favor, the other goes.
You see the judgments tomorrow.
Absolutely.
Some corrections are there.
Obviously.
Item 50.
My lord, I'm grateful that my lord has granted me time to recapitulate my arguments. I was hurrying a little bit. My lord, let me come back to the point which I was trying to lay stress upon.
In this appeal,
My lord.
connected LA appeal,
My lord.
what are the grounds of appeal? On
My
what?
lord, I have challenged that apart from that liability under 28 has been fixed upon me, I have challenged that I cannot be made beneficiary to this transaction at that fastening up of the liability of paying. That is also I have challenged it, my lord. But my lord, if my lord turns to page number 32, my lord, specifically, where the liability has been casted upon OP number 2, that is IIT Gauhati. That is also under challenge in this appeal.
Okay.
Page number 32, my lord.
And otherwise also this issue, rightly or wrongly, is pending before a writ court.
Yes, my lord. That is, and to be very candid with this honorable court, my lord, in my, I had this amount which is there, the decretal amount, has been deposited with the respondent number 6, my lord. Entire decretal amount. Probably this 28, the interest part with regard to the section 28, that is to be
deposited by the central government.
By the central government to the state government. That has been recorded in page number 48, my lord. That fact has been recorded. The state government has acknowledged this fact. Let me read that page number 48, my lord, for a moment. In the writ proceeding.
Okay. You have any? Yes, Mr. What is your name?
Yes, that's my
S. Das.
respondent.
You have any objection regarding?
Yes, my lord. I have objection for.
What objection?
I for stay, my lord. I have to file the written objection. For 2 weeks time,
Okay, till then we are staying. You
My
file
lord.
written objection.
my lord.
You file your written objection. Till then we are
Staying.
staying.
Hearing the matter, my lord. Time after 3 weeks, my lord, I will file the.
You may take 6 weeks. I'm granting time. But till then, the award cannot be executed.
My lord.
In the case, my lord, in the IA, my lord, you have not prayed for history of the execution proceeding, my lord. Only the order passed in the review case, which is prayed for stay, my lord. But execution proceeding is not prayed for stay, my lord. There is a execution proceeding is pending before the learned.
You have not prayed for stay of execution.
My lord. As on this date, and to our knowledge, execution, I have not received any notice to be that way, to put it in this way, my lord. But the execution, they might have filed it. My lord is aware, sometimes the courts takes time to issue notices.
What is the execution case number? And who are the beneficiaries? They are yet to appear.
My lord, steps have been taken upon them, my lord, on accordingly, and that is there in the office note also, my lord.
What is the execution case number?
The execution to study is to notice and notice may be given to you because you are the executing party. No, what I was. For a moment, if my lord turns to page number 48, my lord will see the entire decretal amount has been deposited, my lord, to the state government itself. So how
And why they are not disbursing it?
they should be disbursing it, my lord. It is their duty to disburse it now. Why state government is opposing this application also, I am not fully able to comprehend, my lord. On what grounds state government is opposing?
No, whether any execution.
It is only they will be able to tell, my lord, whether the execution or not.
Let us see the impugn order. What was the direction?
My lord will turn
To whom the district reference?
My lord is, my lord, before that, section 28, my lord is aware that the liability to calculate and everything is with the DC Kamru.
Yes.
Section 28 provision is absolutely clear. However, what the learned reference judge, the reviewing authority has done, is twisted the entire language of section 28 and put the liability upon me. My lord will see para number 37, sorry, page number 37 now. At the bottom of it, my lord, in view of the above, my lord has got that paragraph. Page number 37, my lord, for a moment.
Yes.
In view of the above, the review petition is allowed. My lord, at the last of, at the bottom of it, my lord, page number 37. The view of the above, the review petition is allowed. And it is held that.
Who filed this review petition?
The claimants have filed this review petition, my lord. For reviewing the original judgment. So there were two judgments were there. First, the judgment of that is the common judgment that is dated 23/2/2024 was there. So that, my lord, will find page number 19. But before going that, there, my lord. So in the common judgment, my lord, the court had not granted them in benefit of section 28.
Land Acquisition Act. Yes.
So as I was telling my lord will see. Now let me put it through the seriatim how it has happened. Now the common judgment is passed, my lord, in section 20 on 23/2/2024. At page number 20, it starts, the judgment is starting, and 32 it is ending, my lord. So in my lord is with me.
Yes.
Yes. So page number 32, my lord. It says, in view of the foregoing discussion, the reference case number 83 and 84 is allowed. Petitioners are entitled for a compensation of the land assessed at rupees 125 lakhs per biga, and the petitioner are also entitled 12% interest in addition to the market value of the land as per the provision of section 23(1)(a) of the Act. In addition to the above, the petitioner is also entitled for 30% of the market value of the land in consideration of the compulsory nature of the acquisition as per provision of section 23(2) of the said Act. The OP number 2 IIT Gauhati shall make the payment of decretal amount to the petitioner within 2 months from the preparation of the decree. My lord has seen that?
Yes.
Now, my lord, turn to page number 33. That is the reviewing judgment.
Yes.
Now, what has happened in this, my lord? Let me just read the paragraph for my benefit, my lord.
In the original judgment also, you were directed to pay.
Yes, my lord. In the
Okay.
original judgment also, I am directed to pay.
Okay.
And now in the review was filed, in the review starts page number 33, my lord.
Yes.
With that paragraph, the legal heirs of late Krishna Sundar Barua. My lord has seen that line. Para number 3. Page number 33, my lord, for a moment.
Yes.
The legal heirs of late Krishna Sundar Barua. My lord will see the date of it, 13/6/2025. Of the date of the review judgment.
Yes.
The legal heirs of late Krishna Sundar Barua, represented by Srimati Tanuja Barua, such and such, have preferred this petition of under section 144, read with section 47(1) of CPC and 53 of Land Acquisition Act of the common judgment passed by the court in review in the reference case number 83 and 84 of 2016. My lord has seen that. The next paragraph. The petitioner in the review petition has submitted that the reference case number 83 and 84 were filed for enhancement of the award amount to the petitioners in LA case number 14/1991 for land acquired for establishment of Indian Institute of Technology, Gauhati, in North Gauhati. It is submitted that within the common judgment dated 23/2/2024, this court has disposed of the two reference cases and enhanced the value of the land to 1,25,000 per bigha from 40,000 awarded by the collector in LA case number 14, along with the one-time interest and solutium under section 23A and 23B. The petitioner submitted that while passing the judgment dated 23/2/2024, in reference case 83 and 84, this court has not awarded interest as enshrined under section 28 of the Land Acquisition Act, which the petitioners are compulsorily entitled for the losses suffered by them for the non-timely payment of the actual compensation, and shall further be aggrieved if the compensation is not paid timely after passing of the judgment and order dated 23/2/2024 passed by this honorable court. I pause here for a moment, my lord. And my lord will now see the language of section 28 for a moment.
Yes.
My lord. Now, section 28, the wording itself starts by this language, my lord. Collector. My lord has seen, collector may be directed. My lord has seen?
Yes.
The language prefixed with the word collector may be directed to pay interest on excess compensation. If the sum in which, in the opinion of the court, the collector ought to have awarded the compensation is in excess of the sum which the collector did award as compensation, the award of the court may direct. This provision is not shall, my lord. The court may direct the collector that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land to the date of the payment of such excess into the court, provided that the award of this court may also direct that where such excess or any part thereof is paid into the court after the expiry of the period of 1 year from the date on which the possession is taken, the interest at the rate of 15% per annum shall be payable from the date of expiry of such period and of the 1 year on amount of such excess or part thereof which has not been paid after such expiry. My lord, the entire language of section 28 is couched in a manner where the liability is of the collector to pay, and that liability is the court may give it, the court may not give it also. So one of the point which was argued before the learned reference court was this, my lord, that this is an appeal in the guise of a review. Now, my lord, what has happened thereafter is this, my lord, let me again take this honorable court. So we, against this common judgment, an appeal was filed by IIT. There was an intermediate, there was an CRP also was filed by the IIT and CRP got dismissed. These facts are stated. My appeal, there was some delay and
The instant appeal.
no, my lord, not this one. So
No,
against the
some
common
other-
judgment, there was another appeal.
Okay.
There was another appeal was filed. There was a delay in that, some on the ground of delay, there was that appeal was dismissed against the common judgment.
Okay.
Now, against this judgment also, after the judgment
Appeal was dismissed for as barred by limitation.
as barred by the court has thought ki the limitation, we are not covered by the limitation.
Okay.
So that challenge, whatever the legal EA will take up. But on the fact ki whether IIT is liable to pay or not, that fact has not been decided by any court as on this date. Now, thereafter, my lord, this order of 13/6/2025 has been put to challenge. Accordingly, on last occasion, when this matter was there.
In this appeal.
In this appeal.
Okay.
Because here what this order does is that it changes that original order also. Because the review was allowed. So they have got section 28 interest also.
The review was only in respect of the
Section 28
Section
liability.
28.
And that liability was, the court has said that yes, they should be rightly, wrongly, whatever, that I'm not on the merit of the matter.
But in this appeal, you have challenged.
Yes, I have challenged on the
Origin.
that fixation of liability on me
By the original judgment.
by the original judgment, also by the and the
And
review.
28 liability also.
And 28 liability also. Because in
this appeal, it has to be decided whether you can do so or not.
My lord.
This would be a question to be decided.
Which one, my
Whether after dismissal of your appeal, rightly or wrongly,
my lord.
Dismissal of your appeal on the ground of that the appeal was earlier appeal was barred by limitation. Can you raise the same question while challenging a judgment arising out of the review of the original judgment?
I look at it from a different angle, my lord. Let me put it in this way. Probably I may be subject to this honorable court's interpretation. My understanding is this, my lord. As on this date, the review judgment is only standing.
Oh, yes, because original judgment has been reviewed.
So the review judgment is only changing, my lord.
Yes. Okay,
Subject to
that may be one way of looking at
it. But what I am saying, what I am praying before this honorable court today is a little different. Why I have stated this fact? Because I did not wanted to come with the cloak and dagger and say something which is not there. These facts have been stated in my review petition also, not shying away. So, my lord, what has happened? My appeal has already been admitted on the last occasion. This appeal has been already been admitted. That admission, that order, my lord, will find at page number.
Okay, accepting it has been admitted.
So, my limited prayer, if this honorable court feels that the execution case has not been filed, what I am saying, my lord, as on this date is this: let my application be there. As and when the execution case is filed, I will be allowed to press my application.
Okay. Any objection?
Yes.
They are not pressing it now. Have because the beneficiaries, landowners are not before us. Notice is yet to be served.
Steps have been taken, my lord.
So we wait for the service of notice. They will
And
come.
also I may be allowed to press this application when the execution case is filed. That is my limited prayer.
No, instead of saying so, we are keeping it open. We are waiting for the service of notice.
In the appeal, my lord?
No, in this interlocutory application.
Application has come up for the first time, my lord. Then the my lord will allow me to take steps on the respond number 1 to 5. The money has already been deposited. This entire fact.
We'll not stay without hearing the.
No problem. I'm not. What I'm just saying is this: I may be allowed to press my application as and when the execution case is filed.
Now,
Now let this application be there, because if they
Yeah.
are saying that that execution case has not been filed yet, because it will be issued to the collector, and collector was given responsibility to deposit the money before the execution court. If the collector is saying that the respondent number 6 is saying that no, it is not there, then I may be allowed to press this application when the execution case is there. To my knowledge, I have not been served any notice as of now.
otherwise, on whose request the land was acquired?
On the appropriate government, my lord, in this case was state of Assam.
No, state of Assam acquired the land. You are
And I was not there. IIT
Yeah.
Gauhati was not existent.
in existence at
It
the
was maybe it was central government.
central government.
Maybe central government. Central government is not a party here. If the central government, because I
Central
cannot
government
make
is
any-
made party in this.
No, no, lordship.
If my lord allows, then I will make a central government a party. But my lord will appreciate this. They were not part of the proceedings before the
Reference court?
reference court. The petition, the claimants have not made the reference the EA as a party. The claimants in this case have not made central government as a party. Neither the court has made it.
Now, who deposited money to
The
the
central government has deposited.
So
The money
central government is a necessary party.
Necessary, but at that moment of time, IIT Guwahati
Because,
also
my lord-
not objected it.
No,
IIT Gauhati was not an
apparently,
existing body.
without going into merit and other things, and though a case is also pending affixing the liability, it
Before the
appears that
litigation.
some authority which was not in existence at the date of acquisition, how it can be made liable to pay compensation? The state government must have acquired it on the request of some other authority like
We are already requiring authority.
Ministry of.
But I'll just show something, my lord, if this honorable court deems fit. But this is a document filed by the state government in the writ petition. So they have calculated the amount which this claimants were supposed to get. That is 24 lakhs. I can give it to my learned senior friend also. You can check it out. This amount has been deposited. I'm just for the completion of fact, I'm saying, my lord. If you see the last part, my lord, is 24 lakhs 14,000. Sorry, 24 lakhs 14,000 amount has been deposited. And that has been reflected in the page number of the last page of my order, where they have said they have received the money. This fact was brought by the state government in the writ petition. They have prepared this chart. My lord will see 24 lakhs 14,000. This does not include, in my opinion, probably this 28% section.
Now, one more question. The issue involved in this LA appeal, connected LA appeal,
My lord.
and the issue involved before the writ court are all same.
Almost, I'll be candid, my lord, I'll be saying.
Then there will be there is a possibility of conflicting judgment.
My lord, that is the reason.
Otherwise, when the appellate provision is there,
But the state government has filed that writ petition, my lord.
why he will approach the writ court?
It is not us, my lord. It is the state government who has approached that writ court.
You could have.
We have told the Justice Borua's order was there that no certiorari will lie. However, for looking at the larger interest involved of the landowners, which were 15, 16 LA cases were there. So, my lords have thought ki, let us exercise our power under section 226 so that the issue can be resolved at one go, rather than going into the technicalities. And that is how the Union of India was directed. Union of India paid, and the money is now lying with the respondent number 6.
In writ proceeding, Union of India is a party?
Yes, my lord.
Okay.
So Union of India, my lord, if directs, then I will make Union of
No,
India.
I will not issue any direction, but
they were the party, my lord. Item in page number 40, my lord will see in 48, they are
48.
92, it was 92 of 2020. It was page number 48. They are respondent number 6, my lord. Union of India is already 40.
Third, Mr. A.B. Day, Learned Counsel for the, today only the IA is listed.
My lord.
Learned,
IA.
Learned Counsel.
Connected LA appeal fixed on 6/3/2020.
Okay. Learned Counsel for the applicant. Also Mr. T.R. Gogoi.
Lords.
Learned Counsel appearing for
Respondent number, Lordship, 6, Lordship.
respondent number 6.
Lordship.
This interlocutory application has been made by the interlocutory application has been filed by the applicant/appellant, the Indian Institute of Technology, Gauhati, in connection with alia appeal number 1/2026, wherein the judgment and award dated wherein the order dated 13/6/2025 passed by the Court of London, District Judge Kamrup Amin Gaon in Misje case number 9/2024, arising out of reference case number 83/2016,
83 and 84, my lord.
as well as reference case number 84 of 2016. क्या लिखा है मनमोहन? No, starting से पढ़ो.
Interdiction with appeal number 1 of 2026, where the judge of the order dated 13/6/2025. District Judge Kamrup.
Whereby the review petition. Who preferred the review petition?
By the claimants, my lord, that is respondent number 1 to
Review
5.
petition filed by the respondent number
1 to
5.
1 to 5. Review petition filed by the respondent number 1 to 5 for review of the common judgment and award dated 23/2/2024, passed by the reference court in the aforesaid reference cases was allowed. Stop. Learned Counsel for the applicant has submitted that by the impugn order, the reference court has directed the present appellant to pay the interest under Section 28 of the Land Acquisition Act 1894 on the awarded amount to the respondent number 1 to 5. He further submits that in the common judgment and award dated 23/2/2024, the reference court had also directed to pay the present applicant no,
enhanced
directed
compensation
the
amount.
directed the present applicant to pay original award also. It was
Yes, the enhanced amount, my lord, because
yes.
award was enhanced by 40,000 to 21,000. The enhanced
Oh.
amount to be paid.
To pay the enhanced amount by the present appellant. He submits that since at the time of acquisition of the land in question, in respect of which the aforesaid reference cases were filed, the IIT Gauhati was not in existence, and the state government has acquired the land on the request of the central government.
That, my lord, as per their notification, it is not mentioned. As per their notification, it is their appropriate government.
We are acquiring authority.
They are the appropriate government under section
Not
6.
instructed by central government.
That is his submission, my lord.
Requisitioning authority? From where you got fund?
Lords.
The notification under section 6 were issued by the
No,
state government.
for establishment of an IIT.
That, my lord,
It is
it should be
mentioned.
their submission, my lord, but
No, is it mentioned in the notification?
in the notification, they just acquired the land, my lord.
But you are challenging your liability of.
My liability also.
Stop. Last line, Parok. No, on the basis, as it was the state government which had acquired the land. Stop. Learned counsel for the applicant has submitted that the applicant has also challenged the judgment to the extent of attributing liability to the present applicant to pay the enhanced compensation amount. He also submits that in this regard, the state government has also filed a writ petition
Number 92/2023.
which has been
WPC number
registered as WPC number 92/2023, where the issue
is largely same.
where the main issue before the writ court is also as to who would be liable to pay the enhanced compensation amount. He further submits that since the connected alia appeal number 1/2026 has already been admitted and notices are issued to the respondents during the pendency of the connected LA appeal, the execution of the impugned orders and awards may be kept in abeyance. On the other hand, learned Mr. T.R. Gogoi,
Lordship.
you are aware about any execution case has been filed or not?
No, Lordship.
No.
Execution case was.
Mr. T.R. Gogoi, appearing for respondent number 6, has submitted that at this stage he is also not aware about any execution case filed by the beneficiaries, that is respondent number 1 to 5 or not. As such, issue notice to the respondents. Since Mr. T.R. Gogoi has appeared for respondent number 6, no formal notice need to be issued to respondent number 6. As regards the other respondents, the applicant shall take steps for issuing notice
Usual process and speed post.
by usual mode
And speed post.
as well as by speed post within 7 days from the date of this order, returnable on
4 weeks, no, sir.
after, because the date in the LA case is different.
It is on third.
It is on.
If they
it is
appear,
on 6th of March, Lord.
we'll fix it after that date.
Yes, my lord, let it be after 4 weeks, then it will come. We will.
After 4 weeks, on a date to be fixed by registry.
Let it come in that way.
Regarding making central government party, I am not making any observation.
But my lord will at least give me for the adjudication of this matter, my lord. If my lord thinks that the central government must be hard,
No, it appears.
then my lord has power, my lord, to make them a party and take their views. Because the central issue, who was the appropriate government and under whose direction this land was acquired, my lord, this will be central to this
Yes.
issue, my lord.
If it is so, Lordship, then memo of appeal, the post title of the memo of appeal.
I may be allowed to
Has-
change it by
has to be
hand, my
changed,
lord.
Lordship.
By hand, I will be allowed to change. My lord will make them party by the order of this honorable court. I will make the necessary changes by hand, my lord.
No.
Because otherwise, I could not have made it, my lord. Because they were not party before the reference court.
It appears that in the connected and in the writ petition
92/2000.
number 92 oblique 2023 23, the
Union of India is respond number 6.
Union of India, represented by the Secretary to the Government of India, Ministry of Higher Education, has been made a party. And since during the course of submissions made by the learned counsel for the applicant today before this court, it was submitted that the land in question was acquired by the state government for establishment of IIT is an independent body or
An autonomous body, my lord.
Autonomous body,
Otherwise, an autonomous body. But under fully funded by the central government.
for establishment of Indian Institute of Technology, Gauhati, which was not in existence when the land was acquired. He further submits that the funding of the
Land acquisition.
funding for land acquisition for establishing the IIT was done by the
Part
central.
has been done by the central government. That part
This
part has come from the central government money.
a part of the funding has been done by the central government. Hence, this court is of considered opinion that though in the reference cases from where reference cases in which the impugn order was passed, the central government was not made party, however, for the ends of justice, it appears that the presence of Union of India would be required in this appeal as a party for arriving at a just decision. Therefore, you may file an application. I am not
Okay,
making.
my lord.
Therefore, the appellant is given liberty to file a necessary application for impleading the Union of India as a party in in the connected land acquisition appeal as well as in this interlocutory application.
Let this matter be down, that case,
by
listed on
the
applicant.
applicant, if so advised. Stop. Then
Let it come with the LA appeal, my lord, in that case. Then I'll be able to make the changes. That LA appeal is listed on 6.3. Then let this application also come with LA appeal. I will make all necessary changes
list this matter
on 6.3 too.
on 6.3 along with the
LA appeal one.
connected LA appeal number 1 of 2026. Uparaji asile issue notice. You take steps.
I'll take steps, my lord, immediately.
Fixing the next date on 6.3
26.
instead of 4 weeks.
My lord.
6.3. List accordingly.
Lordship, in this IA, Lordship, government will have to file objection, Lordship.
No, you file objection.
Lordship.
The
Then 60, Lordship, this amendment, whatsoever, Lordship, central government may file. That application he will file.
no, he may file. I have not compelled him to file. Neither it is under court's order that you may file.
And
Court feels that
it is necessary.
it may be necessary, so a liberty is given to the applicant.
Obliged.
Obliged.
Finish.